So thank you for joining us today. Today we have Desmond. He's an attorney from Barley Snyder that's going to be talking to you about the Financial Crimes Enforcement Network beneficial ownership information. My name is Robin Bodine. I am one of the tax partners here at Trout. And at this point, I'm going to turn it over to you, Dan.
Thanks, Robin, and thanks, Trout, for hosting the webinar today. As Robin mentioned, my name is Desmond. I'm a partner in the business group at Barley Snyder in our Lancaster office. I practice general business law, mergers and acquisitions, and I also work a lot with entrepreneurs and startups. Over the course of my practice, I've helped form hundreds of entities. And so when the Corporate Transparency Act came out, I knew it was an area of law that I needed to be well versed in order to help our firm and our clients. And that's what we're here to talk about today, is the Corporate Transparency Act and what you need to know about it. It's a brand new law that went into effect January 1st, and that's why we're here today to timely discuss its requirements, how it affects you, and what you need to do to comply with it. So quick disclaimer here, since I'm an attorney, I have to put this up here. This presentation itself is not legal advice, and it doesn't establish an attorney-client relationship. Good news about that is it allows me to speak freely and offer my opinion and answer questions, which I will try to leave time for Q&A at the end. If you want to put those in the chat, I'll review those as we go through and answer them at the end of the presentation. Quick overview of the Act. It was passed in 2021. It's really born out of the Patriot Act and the Anti-Money Laundering and Bank Secrecy Act, counterterrorism efforts that arose after 9/11. And unlike those laws, specifically the Anti-Money Laundering and Bank Secrecy Act, you might be used to, if you're taking out a loan, having to provide your beneficial ownership information to a bank in order for them to conduct customer due diligence on you. The good news about that is you get a loan at the end of this. The Corporate Transparency Act does not give you a loan or any sort of benefit at the end of your filing. It's just a requirement that all reporting companies need to comply with and provide beneficial ownership information on. And there are actually some differences between what defined as a beneficial owner between the CTA and bank secrecy and anti-money laundering provisions. So the goal of the Corporate Transparency Act is to really look through, shell companies, corporate mazes, to determine who the ultimate beneficial owner of entities are. It's aimed at eliminating bad actors in the terrorism, drug trade, and illegal foreign investment, money laundering industries. Unfortunately, it takes a very broad approach and is going to affect millions of entities who are doing nothing but trying to run their business as best as they can and comply with the law. FinCEN has estimated that it will affect 32 million existing entities and 5 million additional entities every year at a cost of $22 billion, or approximately $700 per entity. And there is no filing fee. That's just the cost of compliance that FinCEN has estimated companies will need to spend to comply with the Act. So the Act will allow you to provide this information to FinCEN, and it will be not a public record or subject to freedom of information request, but it will be accessible by law enforcement, again, if they're trying to go after those bad actors, see who the ultimate owners are of these entities that are doing bad things. And if consent is granted by the entity or the reporting company, it will be accessible to banks pursuant to a new rule that just came out a few weeks ago. So I would expect banks to be requesting this information too, as the information starts to be provided and as we go on. Our agenda today is to cover several main topics. The first is, who does the Act apply to? It does not apply to every entity out there. There are exemptions to the definition of a reporting company. So we're going to go over what makes a reporting company and help you determine whether your entity is a reporting company. We're also going to discuss who is a beneficial owner. As I mentioned, it is not just like a bank application for a loan. You're not just providing who are the actual owners, 25% or above. You're also looking at who exercises substantial control over the entity to determine who a beneficial owner is. We're also going to look at company applicants and who they are. And you're looking at one right now. As I mentioned, I've formed hundreds of entities on a going forward basis starting January 1st. Every entity I directly formed or helped form, I'm going to be listed as a company applicant on that CTA filing. We're going to assess what must be reported, and those categories I just went over is what gets reported. Who are the beneficial owners? Who's the company? Who are the substantial control persons? And who are the company applicants? And also what happens if there's an update to any of that information or there's an inaccuracy in any of that information. What has to happen in terms of how you make that right or you inform FinCEN of changes that have occurred. We're going to discuss when it must be reported. That really comes down to when your entity was formed. Finally, how it gets reported and penalties. In terms of how it gets reported, the Act, as I mentioned, just went live January 1st. The reporting system was live on January 1st. I guess I'm a qualified CTA geek because I woke up on a holiday and logged in around 8:30 and the system was not live. And I thought, here we go, the system crashed, all this build up and there's nothing. I refreshed my page about 15 minutes later and there it was. So I made my first CTA report on New Year's Day. I think I was the 19th ever filed, and I got my FinCEN ID. I think I was the 14th ever FinCEN ID. So since then, I've been filing lots of reports for clients and have learned about the process. I'm including screenshots here today from the actual web portal where the reports are filed to help give some color to the rest of the legalese that I'm explaining here as well. And finally, penalties. What happens if you don't comply? And that really boils down to have you willfully failed to comply with the Act, or have you intentionally evaded the Act? So we'll get to that and what sort of penalties somebody who's willfully not complying with the Act might face. So the first question when you're evaluating how the CTA might affect you and its beneficial ownership reporting rule might affect you is, are you a reporting company as the Act defines it? Again, it takes a very broad definition of what a reporting company is. That is any corporation, LLC, limited partnership, or other type of entity that was created by a governmental filing with a U.S. state. That includes D.C., Puerto Rico, tribal reservations, other territories, or a foreign entity that's formed in a foreign country that is qualified to do business in a U.S. state by a filing. Again, the key thing there is you were created or qualified by a filing with a state. So if that is not the case, you're not a reporting company. If it is the case, very broad definition, you are potentially a reporting company. So I say potentially because this is just a flow chart to help you determine whether you're a reporting company. Again, it basically boils down to, are you a U.S. entity, or are you a foreign entity, were you created by a filing? If you're a foreign entity, were you qualified to do business in a U.S. state? And you might be a domestic reporting company. We say might be potentially because there are exemptions under the Act. There are, in fact, 23 of them. A reporting company does not include entities like governments, banks, bank holding companies, credit unions, large operating companies, which I'm going to get to into greater detail because that is going to be the most common privately held or privately operated sort of exemption that might apply to your entity. Publicly traded companies, certain CPA firms, certain tax-exempt entities, and inactive entities, along with a few other ones. So these entities are deemed sufficiently regulated by the government by other means, other statutes. The government does not need to know as much about who their owners are. It might be public record. They might not have owners if they're a government or tax-exempt entity. So those types of entities are not reporting companies under the Act. If you are one of those entities, you qualify under the exemption, which has specific wording. You do not have a filing obligation. Your wholly owned subsidiaries that are wholly owned or controlled by you also do not have a reporting obligation unless you're one of those four entities I put in that final bullet point there. The only one that really would be commonly seen would be an inactive entity, which I'll go into more detail here in a little bit too. So the first exemption we want to talk about, which I just mentioned, is called the large operating company exemption. And this is what I've termed the main privately held exemption, because if you're not one of those other types of entities that are publicly traded, government, as I just went through, this is one that you could potentially fall under if you meet all 6 of these prongs. And you have to meet all 6 of them. You can't just meet 1 or 2. You have to meet all 6. The chief 2 ones are that you have more than 20 full-time employees based in the United States, you have U.S. operations, and you have greater than $5 million revenue or sales and receipts on the prior year's tax return that you have made. So again, you need 21 or more full-time employees employed in the United States, U.S. operations, and greater than $5 million in revenue reported on your prior year's tax return. Okay, so I'm going to talk in a little bit about holding companies. The large operating company has a bit of a quirk in terms of holding companies, ownership groups, consolidations. You can consolidate revenue on your, if you file a consolidated tax return, you cannot consolidate employees. So if you have 21 full employees throughout your entities as an ownership group, that doesn't work. You have to have 20 or 21 full-time employees at the entity in order to qualify for the exemption, even if you're part of a larger ownership group. Another common exemption that we're going to see would apply to tax-exempt entities, and these are only specific types of tax-exempt entities. So when I'm forming a 501c3 nonprofit for a client, I will file articles of incorporation with the state of Pennsylvania. I just created a reporting company, okay? Because I created that corporation, nonprofit corporation, by filing articles with the state of Pennsylvania. What makes that entity exempt is when it, from the CTA, is when it receives its 501c3 tax exemption, okay? So not all types of nonprofits are exempt just because they're nonprofits. They need to be qualified as tax exempt under Section 501c of the code, Section 527E, which is, super PACs or political organizations, or Section 4947, which is charitable trusts. So only those three types of tax exempt entities are exempt from the Act as a reporting company. If you're not one of those, even if you're a nonprofit, still might be a reporting company under the Act. And again, another quirk of this exemption is going to be that often when you're qualifying for tax exempt entity status, you're not going to get that. Might be 60, 90, 120 days. You're not going to get confirmation of that. As I'll get to in a little bit, in 2024, you're going to have 90 days from the time of formation to make your CTA filing. So if you don't get that 501c status in those 90 days, you might very well be on your way to becoming a 501c entity and be exempt from the Act. But guess what? The Act says you need to make that filing within 90 days. Next year, it's going to be 30 days. So you're going to have nonprofit entities potentially having to make a CTA filing, even though they're on their road to becoming exempt. I'll get to how you do that and what happens if you become exempt after your filing. Another potentially common type of exemption are these entities that are just lying out there in the bullpen, haven't been used for a while. I would term these as truly dormant entities. They were created on or before January 1st, 2020. They don't have any active business. There haven't been any sort of money transactions or ownership changes within the past year. And they've just been sitting out there. Maybe they should have been dissolved again. Maybe they're just sitting in the bullpen. The owner's waiting for them to be used for some purpose in the future. If you qualify for all 6 of these prongs, you're an inactive entity. You don't have to make a CTA filing. Because you're not a reporting company as an exempt entity under the Act. Other types of exemptions, which I've already mentioned, I just want to emphasize these: banks, bank holding companies, exempt credit unions, governments, including in Pennsylvania, entities like Pennsylvania municipal authorities. They're deemed a governmental actor or governmental authority under the Act, so they would qualify as exempt from the Act. Publicly traded companies and certain CPA firms. The test there is you need to be registered under the Sarbanes-Oxley Act, which generally is if you're auditing public companies. So not all CPA firms, only certain ones registered under Sarbanes-Oxley. Where does that leave us in terms of who's in play? It leaves us with those approximately 32 million entities. There's a lot of them, a lot of types of entities that are going to be in play. Any smaller family business entity that doesn't meet that 21 employee, $5 million revenue on prior year tax return, large operating company exemption, you're in play as a reporting company. Real estate holding entities, they're not going to have those employees often. They potentially could have the revenue, they're not going to have the employees, they're not going to be a large operating company. Trusts, you want to look at, were they created by a filing? Were they created by a filing? Again, going back to that definition of reporting company. Are they a statutory trust, is what lawyers call it. If they weren't created by a filing, then they're a common law trust or created by a contract. Most of the trusts you see, those types of trusts, so they wouldn't necessarily be a reporting company just because they're a trust. However, they could potentially have a beneficial ownership role in an entity that they own. And you might need to report information about those trustees as beneficial owners. I'll get to in a little bit. Potentially grantors and settlers and beneficiaries of trust as well. Holding companies, as I mentioned earlier, that subsidiary exemption only runs downhill. It does not run uphill. So if you have a holding company that does not itself qualify as a large operating company, even if its subsidiary operating companies are large operating companies and they're exempt, that exemption does not flow uphill to their parent. It only flows downhill to wholly owned, controlled subsidiaries. FinCEN just put out some guidance on Friday saying their definition of wholly owned or controlled is not that 51% that we see in a lot of other federal statutes. It's 100%. Got to be 100% wholly owned subsidiary. So the statute wasn't really written clearly on that. So they're putting out frequently asked questions about every 3 weeks, it seems, kind of filling in the holes here. That's not uncommon, but there's a lot of, kind of specific guidance that are coming out to specific situations. So if you're trying to determine whether you're exempt, I would encourage you to speak with a legal advisor who can help you interpret those exemptions and the guidance that come out. Because you look at the exemption, sounds like it might apply. Some guidance is coming out. Maybe it does apply. Maybe it doesn't. So joint ventures, if that's not a wholly owned entity, it might not be exempt just because it's a subsidiary, even if it's one or more. And finally, an acquisition, what I would term an acquisition vehicle entity or an M&A type entity. Often when you're doing a transaction, as I mentioned, I do a lot of M&A work. A buyer will drop down a subsidiary to acquire the assets of a target entity or the seller. That subsidiary, once it acquires those assets, unless it's exempt under other means, would not necessarily be exempt under the large operating company exemption. So you have a buyer, let's say the buyer is not exempt, drops down a subsidiary, that entity is not going to be exempt because the buyer is not exempt. And then it acquires the assets of the seller entity who is exempt. But guess what? Those assets are on that seller's tax return, not the buyer's subsidiary's tax return. It doesn't have that prior year's tax return history to qualify as a large operating company yet. So subsidiary would need to file a CTA report. In terms of who that leaves us, who are not in play, really people who didn't make a filing to create an entity to create themselves. That would be things like general partnerships. Me and a buddy just started a business, a market stand or something. We don't file anything with the state. We're not concerned about that. Maybe we have other reasons, maybe we're just not advised, or we do a sole prop. And maybe I start Desmond's market stand and I call myself Desmond's Pizza or something, or Desmond's Market, and I start that up and I actually file a DBA with the fictitious name in Pennsylvania. I'm still a sole proprietorship. I didn't create an LLC to conduct my business, and just because I made a fictitious name filing, again, another piece of guidance that has come out since the act was passed, the fictitious name filing by itself does not make you a reported company. Even though you made a filing with the state, you didn't create an entity. So filing that created an entity did not occur. You're not a reporting company. Again, trust was a filing made to create it. If it's just a contractual or common law trust, not a reporting company in itself, beware that trust might have ownership interests, that that its control persons might qualify as beneficial owners of that entity that it has an ownership interest in. And any other type of instrument or organization body that was not created by a governor filing, so booster clubs, neighborhood associations, if there's no governmental filing creating them, and they're not an entity that was created by a governmental state filing, then not a reporting company. So the second question in terms of who does it apply to are, the beneficial owners, and who, are you a beneficial owner under the Act? There are two ways that the Act defines who is a beneficial owner. They're kind of two prongs you want to look at. The first is that very familiar one, that 25% ownership. Do you have 25% ownership interest? That ownership interest definition is fairly broad. So if you have things like options, then you're going to want to speak to a legal advisor to help you determine what your actual ownerships are, like voting, non-voting stock. But let's just term for now, if you have 25% ownership interest in the entity, you are a beneficial owner. If you have 24, if 20, you're not unless the other way to qualify as a beneficial owner is exercising substantial control over the reporting company. And the Act provides a long list of what they deem substantial control over the entity. So they're not just looking at who the owners who have economic or voting interests in the entity. They also want to know who controls that entity. These are the people who are owned and on the tax return, and we can see all that. But who's actually exercising control over these entities? They deem that important information too. So they provide some bright line tests about who exercises substantial control. The first most obvious one is the senior officer prong of the substantial control definition. If you have a title like president, CEO, CFO, COO, general counsel, or similar function or authority, you're deemed exercising substantial control over that entity. You're a beneficial owner, even if you're 0% ownership, 100% ownership, you're going to be substantial control beneficial owner if you have a title like that. There's also kind of more fact-based or, a little bit less bright ways you can qualify as exercising substantial control over the entity. I put some examples up here. Just want to highlight, I get this question a lot, this being a director of an organization. I'm a director of an organization. It's actually a nonprofit, so that might be exempt under other circumstances. But just because I'm a director, I have a voting interest in an entity. I'm making voting decisions. I'm named a director. That in and of itself does not make me or you a beneficial owner, or you're not exercising substantial control over that entity as the Act defines it. You have to have another sort of substantial control. So maybe you're the president of the organization as well as being a director. In that case, it wouldn't be the director that made you substantial control. It will be your title as president. And of course, the statutes are want to do any other form of substantial control. That's literally what the Act says. So I guess what they're telling us here is if you're on the fence about whether you're exercising substantial control or not, probably should list yourself as a beneficial owner. The beneficial owner is not limited to one person. It's any and all individuals. So it can be any of those 25% or above owners or any of those substantial control. There's no limit on the number of beneficial owners you can have. And obviously, if that's the case, there'll always be at least one person exercising substantial control over the entity. I had a question the other day, real estate holding company. We got 5 members in the LLC. We each have 20%. None of us are owners, so we're not going to have to list ourselves on the CTA filing. I said, no, who's the president? And they had a president in this case of the LLC. And I said, well, that person's definitely exercising substantial control. Got to put their name on there as a beneficial owner. Anybody else exercises substantial control, and it really comes more of a fact-based inquiry, client-to-client, entity-to-entity, who's exercising substantial control. Some of you will be very easy to determine. Some organizations a little more complex or have a little less defined sort of management. So you kind of have to delve into who's making those important decisions and exercising control over the entity to determine who those beneficial owners are. So again, you have that very bright line, 25% or above ownership interest. A little more gray, who's exercising substantial control. Have to look at that a little bit more closely to determine who those individuals are. In terms of holding companies, again, important thing to remember there is that exemption for subsidiaries runs downhill. All wholly owned or controlled subsidiaries, 100%, are exempt. If the parent is exempt, it does not run uphill. If you do have a situation where you're not qualifying under a large operating company exemption, let's say you have a lot of subsidiaries and you've determined that me and my partner, our holding company needs to make a CTA filing. So we're going to put ourselves as beneficial owners on that CTA filing. And then we have 10 more to do for all these subsidiaries we own, which are not otherwise exempt. We can use our holding company as the beneficial owner for all those subsidiary entities. And why do they allow you to do that? It's because I made the initial holding company CTA filing, and then I listed that entity as the beneficial owner of all the subsidiaries. They can put 2 and 2 together and see me and my partner are the owners of those entities, all the ultimate beneficial owners. So just a final rule they issued to clarify that, but doesn't keep you from having to display who your actual owners are, because again, they can just link up those 2 filings. And if you have that sort of JV situation, joint venture situation, where maybe a large operating company would own 30% of an entity that's not otherwise exempt, and that entity has to go make a filing, that 30% parent who's exempt under the act, we can just list their corporate entity name, so we don't have to, just because they're a beneficial owner on the subsidiaries CTA filing, doesn't mean you have to start revealing beneficial ownership about exempt people or exempt entities. You just list the exempt entity's name. Finally, the third part about who the act applies to, again, is who you're looking at right now as a company applicant. I'm directly making a filing, or I'm directing paralegals or other people in my office to make that filing on behalf of clients. When I form entities, I sit down with a client, I take down all the information that's needed to help me prepare an operating agreement, help the formation documents prepared. I send that checklist that I prepare with a client over to a paralegal. He or she prepares the formation documents, and then they file it with the state, generally online. So I just directed somebody to create an entity, and then that person, that paralegal that I'm working with, actually created or submitted the entity filing online, and we both would be company applicants in that case. So unlike beneficial owner, there's a maximum of 2 company applicants. So it can be a beneficial owner as well. If you're the owner of your entity, and you filed it yourself online, you're going to list yourself as a beneficial owner, and you're the one who created, directed, and made that filing. So you're going to have to be listed as a company applicant on there as well. And it obviously expressly includes third parties, attorneys, paralegals, corporate service providers, other people making filings. There was just some more guidance put out on Friday about what happens, really getting into the weeds about what happens when an attorney directs a corporate service provider to make a filing for them. I'll often do that if I'm working in Rhode Island or another state where we don't file routinely. So, in that case, it actually would be me and the individual at the corporate service provider who made that filing, the person who actually submitted the filing, myself, and that person will be listed as company applicants. So again, you kind of rapidly evolving guidance here. And again, a lot of it gets into the weeds, might not be applicable to you, but there are a lot of developing guidance that's coming out. And I think it's going to keep happening this year. We're only 15 days into the year, and this is a brand new act that's very wide reaching, and nothing like it has ever been done before. So there's going to be developments. Okay, so now we're going to talk about what must be reported, and it's really all the information we've covered already in terms of who it applies to, who's a reporting company, who are the beneficial owners, who are the reporting company, who are the company applicants. But what we've done here is I've taken screenshots from the filing itself and showed you what that looks like when you're logging on. So there are 2 ways you can make a filing, and what I've been doing is I've been sitting down with clients, getting the information needed, and then I've been making the HTML or using the web-based filing tool. You can also fill out a PDF and then submit that online. This web-based filing tool is what I've been using, so that's where these screenshots come from. And the first information you have to put in there is actually what type of filing you're making, and I don't know if I have a screenshot of that here. But for most people, that's going to be an initial filing. Some people, it might be an updated filing. I'll get to the context. You need to make updates to that in a second. Some people might be that nonprofit that was formed and they didn't get their tax exempt status within 30 days, which will be the deadline next year, and they had to make a filing application or a CTA filing, and then they get their 501c status. They can also create what's called a newly exempt entity filing. So that's the first thing you got to go through. Then the second is this reporting company tab here that you see in front of you. You're going to be providing the biographical information about your reporting company. So entity legal name, as well as any alternate names or fictitious names, DBAs that entity operates under. So if Desmond's Pizza decided to incorporate, I put Desmond's Pizza LLC, and then I file a fictitious name. I go by Desmond's Pizza. That's what's on the front of my store. Then I would put Desmond's Pizza there. So legal name and any DBAs, where you were formed, your address, that's only going to be a registered office address, where you were formed, or your business address if you're using, in a foreign state, you don't have that physical address within that state. And then your tax ID number, EIN, some way they can link that entity up with its tax returns that have been filed. So the next category in here, I'll skip company applicant, I'll get to that in a second, is beneficial owner. And for beneficial owner and company applicants, it's very similar in terms of the information you reported. The only difference is for company applicants, I put 126 East King there, my business address. Company applicants don't need to reveal their residential address. Beneficial owners do. So they need to put their full legal name, their date of birth, their residential address, and then the identifying number on their driver's license, passport, other types of governmental ID, as well as an image of that ID. So I've been, asking people to take pictures of their license, email that over to me, then I upload that. I found out when I made my first filing, it needs to be a JPEG or PDF file. My iPhone, for whatever reason, sometimes creates these HIEC files. FinCEN doesn't like those. It won't allow those to be uploaded. It needs to be an actual JPEG. So you got to either convert it or get your iPhone to take the right type of picture. So you need to upload that into the screen, into the portal itself. Your scan in terms of a PDF, or if you take a picture of it, the JPEG file of it needs to be uploaded into the filing tool here. You can use a FinCEN identifier. I got one of those because I'm going to be a serial filer and listed on company applicant as for many of these. So it's frankly just saves a lot of time rather than having to upload my driver's license every time or put in all my information. I just put in the 12 or whatever digit number it is that I got when I applied for that on New Year's Day. So you can get that. If you're just making a single filing, I don't know if there's a point to it because you're going to have to upload all that information then twice. You're going to have to upload all your information to get the FinCEN ID, really just creating an extra step. But you can do it if you want, or maybe if you're making multiple filings, that would be more expedient for you to do that. In terms of the company applicant info, I'll get to in a little bit and talk about filing deadlines. The company applicant info only needs to be reported for 2024 entities or later. So if it was formed in 2023 or before, you leave that blank, it's not going to pop up as an applicable field. If it's 2024 or later, you need to include your Dan Desmond or whoever your company applicant was who helped you form that LLC. And again, there's a maximum of 2 of those. The only difference between the beneficial owner and the information you upload, still got to do a driver's license, everything else, you can use your business address instead of residential address. So I talked earlier about my filing process and what I'm doing to work with clients, and what I created here for our firm to use, since we have legal obligations to our clients. We also have obligations when we submit this filing online to attest to its accuracy in terms of who's a reporting company, who's a beneficial owner, and all that information is true, accurate, and correct, and potential civil and criminal penalties. So we've prepared a questionnaire and certificate for clients to go through with them to help them determine, are they a reporting company? A, if so, B, who's your beneficial owners, and go through all that information I just talked about earlier, that analysis. So, and once we've determined that, we can put all this here on a certificate, and this is the information we're going to need to make the filing, and we're asking our clients to certify to that information is accurate, so when we go to make that certification, we can rely on that to make that filing. So this is what we've been using in terms of kind of a tool, a checklist to help that process go more smoothly, make sure everything's being collected and accurately reported to FinCEN. Finally, here's for your, if you're a 2024 entity or later, you're going to need to know who your company applicants are. So that's where you would put your Dan or, the paralegal who's helping and making the filing for me. I would list the 2 people there, and I would list my FinCEN ID, or if I don't have one, I'd upload all the driver's license and all that other information you see here too. I talked a little bit about filing deadlines and kind of giving a preview of that. So the key there is in terms of when must my CTA filing be made, the question is, when were you formed? If you're December 31st, 2023 or before, anytime before that, you have all of this year to make your CTA filing. You've been actually until January 1st, 2025 to make your CTA filing. So again, 2023 and before, all of 2024 plus New Year's Day next year to make your filing. If you're created in 2024, they put out, especially, it was initially 30 days for everybody as soon as the act went into effect. I think FinCEN has realized that publicity as this has been a little waning, or a little wanting, and not a lot of people are aware of it, but for your Barleys and your Trouts reaching out to people to make them aware of it. There's been a little bit of press about it, not a lot for as wide-reaching a statute really, and the millions of people this is going to affect. Hasn't been a lot of publicity about it, and not a lot of people are asking questions. So that's one of the reasons we're doing these types of webinars, to kind of get publicity out there, but also help people understand their obligations. So all that being said, 2024 entity, new rule said you have 90 days. We'll give you an extra 60 days to make this filing because we know this is brand new and not a lot of people are paying attention. Get an extra 60 days to make your filing. 2025 or later, that's 30 days. So it's really not a lot of time. So when we're forming entities, we're making our CTA filing right away on behalf of our clients. Why wait? There's no reason to wait, and you could potentially violate the act and be subject to penalties. I'll get to here in a bit. One other thing you need to be aware of is the CTA is a one-time filing, potentially. I say potentially because if you're a reporting company, you have to make that filing the first time. If nothing about your reporting company that you put on there, all those screens I just went through, your beneficial owners change, then you'll never have to make an updated or corrected filing. But if a beneficial owner were to change, I work with clients a lot on succession planning, people handing down family business to relatives or maybe just, outside third parties, employees. Anytime a new owner would come in, again, 25% or above, or a new substantial control person, we'd have to update that. Or anytime an old owner left and they were no longer a beneficial owner, we'd have to update that. Address changes, name changes potentially. So things like that, you have to update and make a updated filing within 30 days of the occurrence of the change. Not a lot of time. So you do succession planning effective April 1st, you got to make that new updated filings showing who those new beneficial owners are by May 1st. Okay. Let's say I make my filing and I put in the wrong address, or I spell the name wrong, or there's some other sort of inaccuracy in there. I forgot an owner. Wow, actually I forgot we had this guy we just named COO or something. And I made the filing and I didn't put him on there. Then I'd have to actually update my filing within 30 days of my awareness of the inaccuracy. So I become aware of that inaccuracy on April 1st. Let's say I made the filing this month or before April 1st. I become aware of the inaccuracy. I have until May 1st to report. Let's say I became aware of it, but I was a little busy that month and I didn't make it until, let's say, June 15th. That's about 75 days that I've let go there. The act says, listen, it was 30 days. You had the obligation to make a correction in there, but you made it in 75 days. That's less than 90. We built in a 90-day safe harbor, so you won't face penalties. You violated the statute, but there's a safe harbor. You're not subject to penalties. That's a built-in safe harbor. We don't really know much about enforcement yet, so we can't really say what enforcement's going to look like. We do know that's a built-in safe harbor. So if you take those 90 days to make your corrected filing, you will not face penalties according to the act. Another thing we're recommending, it really for any ownership agreement, but certainly if you're updating or creating a new entity, we're putting into our form operating shareholder partnership agreements, form language that requires the members, shareholders, partners to inform their company if any of those changes have just occurred. So I moved, I actually sold some of my interest to Jill, and now she's an owner too, and I got to make the company aware of that. I got to help them comply. And guess what? The act has penalties that can potentially apply to beneficial owners, reporting companies, and company applicants. All three of us are in that potential bucket there. Any of us who willfully violated the act are in the potential penalty bucket. So you got to let your company know if any of these things changes. So we build in some language affirmatively stating that owners will agree to that. That's what you see in front of you here. Again, just one way we're trying to help people comply with this. A lot of it's not obvious. These transactions and these changes have been going on all our lives, all the business history. We have a new act that's going to require what were once, routine or mundane things to make a filing with the government, which is a brand new requirement. So anything we can do to help people and, alert them to that or help them on a going forward basis when they form their entity, we're putting in language in there to help companies comply with that. Again, beneficial owners, reporting companies, company applicants, all potentially liable under the Act for, willful violations of the statute. So it doesn't matter if, it's not one of those things where the company only is on the line. Criminal penalties, the company's not going to jail. I obviously don't want to scare anybody, but there are criminal penalties built in. Companies don't go to jail, people do. So, if there's imprisonment, enforcement actions handed out, they're going to go after the owners or, potentially company applicants. If I'm helping a client willfully evade the statute, I'm just violating a federal law. So, not a good idea. Finally, how does this get reported? I just showed you screenshots throughout the kind of the report that you go through, and this is the actual link to open up this filing tool and make that filing. And here's that initial screen you see here in terms of the type of filing you need to be made. One of the first questions that obviously came out is I'm sending all this stuff into this web-based portal. I'm uploading my driver's license, all this sensitive information. What happens to it? It's going to be housed on FinCEN server. In most cases, I think the federal government probably has all this information about me anyway. So I guess this is just kind of linking up the two with them and not giving them any new information they have about me. But that's not going to be subject to, that's not a public record. It's not like when your township has a contract or something and somebody files a right to know request. Or a federal agency has hearings and records or depositions or something, and I file a Freedom of Information Act request to find out, get a transcript of that hearing. It's not like that, okay? This isn't a public record, and I don't have access. I don't have a right as a citizen to have access to your filings. So it is secure, housed on FinCEN Center server, and it presumably can be accessed upon request by a law enforcement agency. They haven't really revealed much about that. I don't expect them to, but presumably any law enforcement agency who wants this information will submit a request to FinCEN, who are the owners of XYZ entity. FinCEN will provide them the report so they can see that. If they're conducting, again, go back to the reason for this statute is to go after these bad actors. If they're conducting an investigation into an entity, they want to know who the owners are. So this is one way they'll be able to get that. Pursuant to a rule that was passed last month that I mentioned earlier, banks are also going to have access to this information. So I imagine that when you apply for a loan, there's going to be some request to have access to your beneficial ownership report because banks need to do customer due diligence on who their customers are so they can comply with their regulators who require them to do that under Bank Secrecy Act and anti-money laundering regulations. So they're going to want to see that too. And if I want a loan from them, I'm going to grant them access. So anybody in the banking industry, there's been some regulations put out about that recently. I would stay tuned in terms of further developments there and how that's all that's going to work in terms of banks getting access to information. But two sets of parties, the financial institutions and law enforcement, are going to have access to that information. Otherwise, it should be kept under lock and key in FinCEN server. Mentioned earlier about potential liability for somebody like me as a third party submitting this filing on behalf of somebody. Why do I want you to complete that certificate? Because I'm certifying to the government that everything I've put in here is true, correct, and complete. I have authorization to submit this on behalf of an entity, and this is actually a screenshot from the filing itself in big bold letters reminding you of the obligations. So, obviously that information needs to be accurate. And if you're getting that, from third parties, maybe you're just making a report or your attorneys are making a report, they're going to want to rely on that information is accurate when they go to make that filing for you. Okay, so I kind of colored this throughout the presentation. Yes, there are penalties for violating the act, and it really comes down to has the individual or a reporting company willfully violated the act. You know, a term a lot of statutes like to do. It just means intentional misconduct, willfully violating the provisions of the act, failing to report the information, lying or fraudulently reporting who the owners are, things like that, or just completely ignoring it and not making a filing because I don't want to reveal that information to the government. I'm doing something bad I don't want people to know about. I want to keep hiding behind my LLC. It's not going to work, okay? You're going to be in violation of the act, and you're going to potentially face civil penalties of $500 per day, criminal fines of $10,000, imprisonment up to 2 years. So obviously, like I said at the beginning, everybody, these 32 million entities, 99.9% of them are just trying to run their business and do things legally and comply with the law and take care of their people. Get this filing made. Don't, your people are going to be aware of it. Don't let it slide. You mentioned there are safe harbors for corrections made within those 90 days, but 2023 or before, get it done this year. You've just created 2024, get it done when you file the LLC, just get it over with. Next year, definitely get it over with because you're only going to have 30 days. And I get a question a lot, well, only the company's liable. Again, no, everybody who willfully violated the statute is going to be liable. So if I gave all my information to my company and it's one of my other members of my LLC who's the bad guy, I'm not going to be potentially liable because I didn't willfully violate it. But as long as I'm not impeding that filing being made or doing something else, the person who's providing wrong information or aiding and abetting that reporting company potentially is liable. So not a criminal lawyer by any means, but it's pretty clear here if you're intentionally violating the act, you're going to potentially face penalties. And the real takeaway there is willful violation of the statute. So we're not talking, foot faults or things like that, or unintentional violations, but really an intentional, aware violation of the act and its requirements. So what have we been doing to get ready for this? Just to kind of highlight, we formed a task force within our firm. We've been spent most of 2023 getting ready for this because of the obligations for our clients, but also obviously, as you've learned today, law firms have obligations of themselves as company applicants, and people filing these reports have obligations as filers who are checking that box saying they're certifying that all that information is correct. So we've been really, trying to comply and help our clients comply, but also just getting the word out. As I mentioned, the publicity has been almost non-existent of this act, except for the Barleys and Trouts of the world and people trying to reach out to their clients through client alerts. I've given multiple presentations on this, including CLEs at the Bar Association, a chamber webinar, this webinar here you're here for today. So we're also reaching out to our clients. I mentioned I use checklists when I form entity. Every entity I've formed since 2011, I have a checklist, and I'm glad that I had that checklist because when I was saying, okay, who do I need to reach out to? Who do I need to make aware of this? We can send a mailing list out to everybody in the world, but not everybody pays attention when they just get a generic mailing list item from Barley Snyder. But I've gotten a lot of responses when I say, hey, I helped you form this entity. You might have an obligation. We talked about an entity. I'm aware you have entities. We got to talk about this to see if you have an obligation to file here. So direct individual outreach is really the name of the game in terms of making people aware of it and getting people focused on it. But certainly, we're taking all those approaches and above to let people know. And, it's great that you're here today because you probably got an email from Trout saying we're doing this webinar and it has some information you should be aware of. So it's working, but we just need to spread the word a little bit more. And we got to keep doing these sort of things and making people aware of it so that none of these 2023 or before fail to get their act filed, and going forward, all these entities created, make sure they know they have this filing obligation. We formed for our CTA team, we formed a website, and this is something you can click on, and it'll have links to all the FinCEN guidance, all the new frequently asked questions that come out. One just came out Friday, so I'm updating people on new guidance that have come out. And anytime there's a new development, it's going to be posted there. So that's an area you can kind of go as a landing page to stay abreast of changes in the statute. Or if I have questions, who do I need to contact? Who do I want to contact? It's everybody on our CTA firm, CTA team is listed there. And obviously, if you work with anybody else in the firm, you can reach out to them. And if they don't know the answer, they can get you to the right person who does. How we've been implementing, well, in addition to actually making the filings that we've been doing for the past 2 weeks, we're using that questionnaire and certificate. We're using that form operating language. We're creating a database for all entities that have ever been formed by Barley Snyder going forward. I don't think that's something most law firms had, or any law firm really had, for all the entities they've ever created. So that would have been great to have, as we just say, mailing lists, collate, and reach out to all those entities we ever created, email address. But obviously, entities go back a long time. You didn't have all those email addresses or send them a letter or something. So we're going to do that going forward. One of the reasons for that is the name of our task force is the CTA, an annual reporting statute task force, and that is in reference to Pennsylvania's annual reporting statute, which is going into effect January 1st, 2025. So we got a whole year to get ready for that too. Kind of similar to CTA, not similar in other ways. But unfortunately, one of my favorite parts about filing an entity or creating entities in Pennsylvania is not only because I'm an attorney here, but because they didn't have an annual reporting statute like other states. They didn't have to make that yearly filing. Well, Pennsylvania's joining the ranks of all those other states that require that annual report. So on a going forward basis, any entity in existence in Pennsylvania is going to need to make that annual report filing. Stay tuned for that. Okay, in terms of if you have any questions, and I'll try to get to the chat here in a minute, but if you have any questions, you're more than welcome to reach out to me or anybody else at the firm, and anybody who has knowledge about this you'd like to reach out to. And if they don't know, then they can reach me or whoever at the firm that they would like to refer the matter to. But there's also, the guidance I mentioned earlier, and I've taken screenshots from some of their the small compliance guide you see linked to here. And that, kind of puts the act into greater detail than the statute itself does, and really tries to answer some of the more particular questions. And then since that has come out, they're also updating their frequently asked questions. That's what the second thing you see linked to here. So as these gray areas and holes in the statute are realized by regulators, they're trying to fill in those holes and make those areas not so gray and answer questions about them for people. So something obviously I'm checking a lot, and I get alerts anytime there's an update to that, and scouring through to see what's been updated. So there's a link to that. If you have any questions about those guidance, as a lawyer, I can understand most of it, but I can understand that it might not be applicable to a lot of people in what they do. So I can help you understand those if you have a question about that. Finally, visit our website, reach out to the right person, or just click on there to see if there have been any developments in the law. So I'm going to pull up the chat here, see if I can help any people with questions. What is the site for the web-based filing? That was that BOIR.efiling.gov. Don't quote me on that, but if you go back a few slides, and I'll be happy to share this slide deck with Trout, who can distribute it to all of you. If you go back on that slide deck to the BOIR.efiling.gov or whatever it was, then that is how you make the web-based filing, by clicking on that. And actually, I see Robin linked to it, the very next one down there. So to clarify, you said next year you'll have 30 days. Yes, by next year, if you're created in 2025, 2026, 2030, whenever, after 2025, you're going to have 30 days to make your filing. Does a large operating company apply for a company that is a LOC, apply for a company that is an ESOP? I think it could potentially, not an ESOP expert by any means. I probably want to talk to you a little bit more about that one-on-one, or loop in one of our ESOP attorneys. But it could potentially, if they meet those 21 employees, 21 full-time employees, or $5 million in revenue, but not my area of expertise, ESOP, but there's no sort of carve out for ESOPs. I can tell you that. It's any type of entity who would meet those 6 prongs. The 2 most important being that $5 million in revenue on prior year tax return and 21 full-time U.S. employees. Yeah, I've been getting a lot of questions about, is this the practice of law, making a filing? I don't know if I can provide a perfect answer for that, but what I can tell you is if you're looking at exemptions and statutory language and regulations and determining am I a reporting company who's a beneficial owner, to me, that's a practice in law. That's what lawyers start out doing is interpreting statutes. Yeah, I think that's a practice of law. So I think that's probably the best way to answer that. Question about consolidated returns. Really, you need to have the revenue on a consolidated return. You can't consolidate employees. So that's probably the best way I can answer that. If you don't meet that revenue test on the consolidated return for your ownership group or affiliated companies, then you can't aggregate. And I just want to be clear, you can never aggregate employees. Employees has got to be on an entity by entity basis. So just in case I wasn't clear on that, you can consolidate revenue under the large operating company exemption. You can never consolidate employees. Yes, a copy of the presentation will be made available. We recommend I coordinate with the attorney that set up my entities to help me file. Certainly, if they're capable of interpreting the act and providing you advice on who a reporting company is and who beneficial owners are, I'm sure you can reach out to them. They can, if they're not, you can reach out to somebody who is, an attorney who is, and help you make that filing. You don't, just because, say, I formed an entity with an attorney in 2015, that has no bearing on who makes my filing, or they're not even going to be listed as company applicants unless that entity was formed 2024 or later. So, and if any of that information changes, every time you change attorney, you don't have to update who your company applicant is, because they're really concerned about who made the filing at the time it was created, and that's a static field. So if your company applicant's name changed, their address changed, firm changed, whatever, it doesn't matter. You don't have to update any of that information because that's a static field, and they're really only concerned about who was that person at the time of filing. But presumably, so they knew how to ask questions if there are mistakes or things that aren't clear to them. Yes, somebody has a question. Are real estate holding companies and large operating company exempt companies need to file? If you're a subsidiary, any type of subsidiary, then you would qualify as a wholly owned or controlled entity. So if your parent company is a large operating company, or you fall under some sort of other exemption, then you would not need to file. But really, that's that only kind of privately held exemption. So if you're not meeting that test, or your parent is not meeting that test itself, then you probably are a reporting company. You probably have a filing obligation. All right. So it's 12:59 on the.
Sorry, Dan, can you just clarify on that?
Go ahead.
I mean, we have many. I want to be clear on this. We have many real estate entities that are owned by individuals that lease to large operating companies. Can you be clear on whether the real estate entity has to file in that example? So I have an LLC. I'll be specific. I have an LLC that leases to a large operating company. Does the LLC that leases to the large operating company, separately owned by individuals, does it have to file?
Yeah, I think in that situation it would. It wouldn't, meet the subsidiary exemption. It wouldn't, standing alone, meet any other exemption I'm aware of. Yeah. So those sister entities, just the leasing relationship itself does not create any sort of, CTA relationship that deems you exempt.
Thank you.
yeah, you got to hit one of those 23 exemptions. So, well, it's 1 o'clock on the dot. So I appreciate everybody tuning in, and feel free to reach out to Robin and I if you have more questions. So thanks everybody for joining us here today. And again, if you have any questions, feel free to reach out to us. And my information is on the slides that you'll get from Trout. So appreciate it, and hope everybody has a good year. Take care.